Namaskar. In this episode of Dil Se, we'll be talking about perhaps the most fundamental issue that confronts our country, which is the state of the judiciary, and in that context, the independence of the judiciary. Now, the three of us who are present here, in fact, the four of us who are present here are all lawyers. We've been practicing in court for years, some of us for decades, and our interest in maintaining the integrity of the institution is fundamental because we believe that without judges being fully independent, the delivery justice system will not function. So what are the problems that are facing the judiciary? And incidentally, when we do this program, it is not meant to denigrate anybody, not meant to attack the institution, but meant to look at issues in a constructive manner to make the system more efficient. Someone said that, if you really talk to lay people in the country, they've started losing confidence in the institution, and that's not a good thing. Now, what are the reasons as to why they're losing confidence? A part of the reason is the process of appointment. Part of the reason is that nowadays we get judges, more and more judges who are on government panels and then are appointed to the judiciary. In principle, we can't be against that, but we see the consequences of that in contemporary India. We've had a judge recently of the Allahabad High Court who has been now, some in-house proceedings have been started against him for what he said. And what he said was completely unacceptable. If you remember, there was a restatement of principle as to how judges should conduct themselves in public life way back in the 90s, which prohibited certain conduct of judges, which the judges don't follow. So we have three extraordinary people with us today, people who are leaders in the profession, those who have made a mark in the profession, leading lights of India in a sense within the judicial firmament. Who are going to discuss some of these very complex issues with the intent of actually giving a constructive analysis of what has happened and what should be done. So we have Mukul Rohatgi. Who doesn't know you, Mukul? You did your bar and became a member of the bar in 1978, became a senior advocate in 1994. You were AG of Haryana, Advocate General of Haryana in your 90s. You became an ASG in 1999, rose to the top position in the country, that of the Attorney General in 2014. But then, of course, gave that up, back in private practice. And every time I open the newspaper, you're there. So thank you very much for being here.
I'm after you in the newspaper.
Dushyant is a maverick. Maverick in the sense that he speaks his mind like nobody else in this country. Just nobody else. He also joined the bar in 1978. And his father was a judge of the Gujarat High Court. He practiced in Gujarat from 78 to 86, then moved to the Supreme Court of India. I remember having a conversation with you when you came here. And he was a member of the National Law Services Authority. And whenever there is a crisis within the institution, you will have Dushyant Dave speak his mind. Because I think that he is one person who is unafraid of the consequences of what he says, which some of us are, but you are not. And I admire you for that. I think you wrote a letter to the Chief Justice of India in 2023, when I think you were president at that time, when you told the Chief Justice, why are matters being allotted to a particular judge? Right? You didn't get a response, I believe. But that's what it is. Recently, I saw you in a wonderful interview with Navika Kumar on a channel, and you said some great things. Again, spoke your mind, and we all admire you for that.
Thank you so much.
Another very, very leading light in the profession, Meenakshi Arora, is here. And she, since 1985, has been in the Supreme Court. But before that, Meenakshi was working with a law firm in Washington, right? A firm called Goodman and Sobel. Then you came to India, you became a partner in a law firm here,
Before that, she was my colleague in Ahmedabad. She started her career with
my
me.
career in Ahmedabad.
That's why she has embraced the qualities of being independent and speaking her mind. So she became a standing, 2006 to 2013, you were standing counsel for the Election Commission. 2013, you became a senior advocate. You're involved in the Vishakha guidelines. You were involved in the, sexual harassment of women in the workplace, the guidelines that were framed by the court. So you've done some wonderful public service, and you also have the quality of speaking your mind.
And what most people don't know about her,
She was offered judgeship of the Supreme Court, which you declined.
But she declined. She declined to be a Supreme Court judge.
Okay, well.
Which is a big loss for the country.
I agree with you. So there it is. Mukul, let me start with you and ask you the question. What do you think is fundamentally wrong with the system?
With the judiciary?
Yes.
I think, Kapil, there are a host of factors. It's not possible to pinpoint only one. The nature of appointments, the fact that judges have usurped the power unto themselves to appoint, virtually saying that we know the best and we don't want any other person to be in that appointing authority, whether it be a lawyer, whether it be a member of the government or anybody else. And in that context, there is no transparency. Even today, there is no transparency. Except now there is a short note coming out that we have appointed or looked at X, Y, or Z, but that's not transparency. They don't say how many people we have interviewed, how many people we have seen, etc. we have appointed. That's not going on. So that's a problem of appointments, which I personally feel has gone on even beyond the NJAC case. There is no law which allows the court to appoint members to the court. There is no law.
There is a judgment of the Supreme Court.
There is no law, written law of Parliament or the Constitution of India which allows that. It has been so interpreted, and I think wrongly with respect, to keep the power to yourself. That is one problem. The other problem is that we have cases clogging the courts. And it is going from bad to worse. The system is collapsing. The collapse has started. And I would only recount what I read in the paper about Allahabad High Court, in which you had appeared.
Yes.
And the court made very disconcerting remarks. Yes. People are losing faith because of clogging of the system. Clogging is because of a variety of reasons. Again, the quality of judges who are appointed, their capacity to dispose of cases, the myriad laws and the labyrinth of laws which requires to be simplified. You look at the Income Tax Act, it is this thick. Nobody can understand by the time you are done with it. So you don't simplify laws.
The sentence runs into paragraphs.
So you don't simplify laws. You don't simplify the nature of resort to appeals. Laborious laws, some going back from 100 years, going on and on. That's yet another aspect. And ultimately, the stuff which is being appointed is frankly, if you ask me, not up to the mark. For various reasons. Sometimes that person has no experience. In the sense, in the last 25 years before you become a judge, you've done hardly few cases. If you don't have experience, you're not able to deal with the job. You're not up to the mark. So I would say these are a host of factors which is afflicting our judiciary, and a multi-pronged approach is required, starting from the manner of appointments, the declogging of courts, simplifying the laws, simplifying the nature of appeals, and then we can look at something. Otherwise, I'm sorry to say that in our lifetime itself, this system will completely collapse.
So tell me, on the manner of appointments, Dushyant, the Supreme Court has so to say, through an interpretive process, taken over the power. But when you take over the power, you have much greater responsibility to deliver, right? And I think that we are all ad idem that responsibility has not been discharged in a manner that satisfies the lay people in the country. So what would you suggest as to how to deal with it? And if you want to start a process of change in the manner of appointment, how do we go about it?
See, before I answer that, Kapil, let me tell you one thing. That one fundamental desire of people, which is today not being met with by the constitutional institutions, is their clamor for justice. There is a lot of injustice in our society, be it at the hands of the government, be it at the hands of the powerful and the rich. People are suffering. I mean, this includes all kinds of people, government servants, business community, landlords, tenants, workers. Everybody is suffering. The criminals who are being tried, falsely implicated, even those criminals who, are being tried and convicted, they are not getting relief in appeal courts, The judicial system, as Mukul very rightly points out, is not collapsing. To my mind, it has collapsed. And I really commend you, Kapil, for starting this dialogue, because it needs a nationwide debate.
Right.
Because what we are discussing is complete negation of rule of law.
Right.
And if there is no rule of law, there is nothing called democracy which is left in the country.
Right.
Now, you have 5.5 crore cases pending in courts across the country. You have thousands of cases pending in each high court, 80,000 cases in the Supreme Court. As Mukul says, I mean, you can never really dispose them of during our lifetime. Maybe even for next 100 years at today's speed. What is really missing is that the per capita ratio of judges is perhaps one of the lowest in the world in India.
That's correct.
And government is not interested in really increasing that. So it requires an awareness, it requires a great discussion, debate, and perhaps it requires tremendous pressure to be brought on the government to make sure that more judges are appointed, more infrastructure is created. But that's one aspect. The other aspect is that, as you rightly said, what about the appointment? Now, when judges, I would say, took away the power from the government to appoint High Court and Supreme Court judges, the fundamental basis for that was that we will appoint best from those amongst available.
Like Shekhar Kumar Yadav.
And not appointing judges like Chief Justice Murlidhar, Chief Justice Akil Qureshi, and Chief Justice Jayant Patel from Gujarat, and many, many others. There is no doubt in my mind that after 1992, the quality of appointments to High Court and Supreme Court judges has been, seriously flawed. And they have definitely not appointed the best from amongst those available.
Was the appointment process or the quality of judges better prior to 1990?
I would definitely say that it was better. Yes, it was not perfect.
Yes.
It was not perfect, but it was better. Today, judges...
I would endorse that.
Yeah.
I would endorse that. Yeah. I mean, you see...
No, I would endorse it too.
Yeah.
Yes.
You see judges like Chirappa Reddy, APC. I mean, you can have a list.
Correct. But there are problems with that which will be created if a political establishment
from
of
Gajendra
the
Gadka downwards, we had excellent judges which the government had appointed.
That's correct. That's correct.
What is it that suddenly has happened? Once you've taken over power, why is that last 50 years experience gone down the drain?
Because there is complete nepotism in appointments. And this is what, every collegium, I think all of us know, in high courts, when it sits, every member of the collegium has his or her nominees. And it is give and take, which leads to the appointments. Right. Same thing happens in the Supreme Court, we know it. Now, the issue is today, Kapil, that nobody in the judicial system is willing to address the problem which is plaguing the country. No Chief Justice in last 30 years, 35 years since I came to the Supreme Court has ever cared to really go into it, except Justice Amadi did to somewhat extent. And believe you me, every Chief Justice on his appointment has received a letter from me, mostly handwritten letter, in which I have begged them that you do something about it, however short your tenure may be. Consult IIM Ahmedabad, consult IIT Technology Delhi, consult best of the lawyers, best of the judges, best of the stakeholders. and find some solution to the problem. But no Chief Justice has shown any interest, including responding to the letter. I am really disappointed to say that we are part of the institution, we love the institution. See, today, therefore, there is nobody to guide the district judiciary, this subordinate judiciary, nobody to guide the high courts. And Supreme Court, if Chief Justice Chandrachud, during, constitution bench matters could come 45, 50 minutes late on virtually an everyday basis, which we saw during 370 hearing, or many other times, that percolates down. Now, judges need guidance, and unless you deliberate with the members of the bar, people who have vast experience like Meenakshi here, Mukul here, or you yourself, judges have to talk to them. Judges must talk to every good lawyer in every high court, every district court to find out what the problems are.
That conversation is missing.
Nothing. There is no effort. There is no desire. Every Chief Justice comes only to while away his time looking at the SLPs, which is not his function. Believe you me, deciding SLP is not what head of the judiciary has to end up doing. So you look at Chief Justices after Chief Justice.
That's another debate we'll enter into. But let me ask you, Meenakshi. People have a tendency, and that's human nature. If you get power, you don't want to give it up.
Yeah.
Right?
Obviously
now, in fact, that is a fundamental flaw in any appointment process. Because unless the process of appointment is democratic, right, you will never get the right kind of person on the job that you're looking for.
Absolutely.
So what should be done to make the process more democratic, according to you?
I think, first of all, you need to have very transparent heads under which you would do. Now, I'm being very, very, let me say, bookish maybe to an extent. You have to have fundamental heads when you're going to appoint judges. Of course, knowledge of law, integrity, a very high factor there. Team player, I would put it today on a very high pedestal, because Supreme Court is not one court today, it's 16 courts. So a team player is a very important facet of judges that you appoint. Every judge who will come there may have some of his own beliefs or leanings. But when you select them, you have to see whether this judge is capable of rising to the occasion to be above himself when he presides as a judge. That is, to leave his ideology, beliefs aside.
But how will you get to know that? I mean, how can people in the Supreme Court?
It's not difficult, according to me. Now, I'll tell you, in that whole set of people that you have selected, as you have said, you've had people like Muralidhar, you've had people like Akhil Qureshi, you have had many others that I can say today who never reached the Supreme Court, though they should have. But they did not come because of anybody's reference. They came by the grit of their own work and determination, whatever. So you were able to pick some good judges because you needed the merit and for people to work. But at the same time, you want to have some of your own there, if I may call that so. And in that process of having your own, you pick people only who toe your line or speak your voice, and you believe that once they are there, they will again speak your voice. The problem that is happening is, when you pick the people who will speak your voice or have a political strong ideology which will speak what their masters want them to speak, they are not capable of delivering work. You do not look at their ability, you do not look at their knowledge of law, you do not know whether, and I have been told this from someone within the system, that take for example, now this is not from there, but just take an example, Allahabad High Court. There are barely 25, 30 of them who actually work there. Many are not even able to dictate a 2-line order in the court. And those are many of them among them being the recent appointees. If we are going to fill our judiciary with that kind of appointments, well, the doom is there probably, or as Mukul says, it's not too far away. It's already there. And that's what we have done.
Yeah, but for that to work, you need to bring the bar on board. You need to bring successful members of the bar on board for discussion, right? You need to have a committee much before a process of appointment takes place, in which there are representations of the bar, of the judiciary, right? Of the high court in which that appointment is to be made, of leaders of the bar there, of people in the public who have a status in society, and you have to discuss each judge threadbare, each prospective candidate threadbare. What are his qualities? What is his background? You know, I have no problems. There are many people with ideologies who have come to court and been fabulous judges. Krishna here is one of them, right?
But,
Subara was another, right?
Kapil, may I just say something here while you are at it? I am given to understand, I could be wrong completely. I believe Justice Yadav, about whom we were talking a few minutes back, had been actually turned down by the previous Chief Justice completely.
Yes, correct.
So I would ask myself a very, very important question. Having been turned down by somebody else prior to you, what was the difference that made you appoint him? And we've seen the result.
Meenakshi, I don't want to go to individual cases because there are several cases where there are IB reports, anti-IB reports, and all. Let's not go into all that.
At the end of the day, it goes back from what you are saying. It goes back to one basic question. You must have a broad-based, transparent committee.
Absolutely.
Call it NJSC, don't call it NJSC.
Yes, correct.
Couple of members of the bar, from the Supreme Court, from the High Court concerned, Chief Justice and 2 judges of that High Court, maybe a government representative, law secretary from there, some well-meaning individual from there, of that state, a prominent person who has no axe to grind, who may be 70, 75 years of age, who has no personal axe to grind. If you have that broad base and say, now we have a panel of 5, what do you have to say? You say something, he'll say something, she'll say something, and then you look at it. But if you do it, as you said, I scratch your back, you scratch mine, sitting in this room.
And in complete secrecy.
But
then
Mukul,
secrecy.
I agree with you, but it should be away from government. It should not be a government committee at all, if you ask me.
No, I'm not saying government committee.
It should be a
forget NJSC.
official
But
process.
I would still say, Kapil, one member of the government should be there because they're also a stakeholder.
No, of
They're
course.
the largest litigants.
No, they must be there. What I'm saying is it should not be under the control of the government.
Don't make it a majority.
It should be under the control of the court, and the committee should be given the power to recommend.
See, the real problem is this, Kapil, that, you'll go abroad, you'll find that even if one important post, let's say of a director of a famous institution or a vice chancellor is to be made, the process starts 1 year before the incumbent is to retire.
That's correct.
We don't start that process till after. So you have today almost 50% vacancies in high courts like Allahabad and Gujarat. So unless and until we can take the government on board also and make the government understand. See what is happening. We are now appointing, judges, or government is only clearing those judges who are oriented in a particular way. And they come from, essentially the pool of these high court judges is coming from government lawyers, which is hurting the institution. So we need government also to, understand, realize that this way it doesn't help justice delivery system. And therefore, unless and until everybody sits together, puts their head together and decides that we have to be scrupulously independent and scrupulously sincere about appointing judges to high courts and Supreme Court, and we will select the best irrespective of their ideologies only on merit and merit alone, then only we can, deal with this situation. That is a far cry. That's a dream which we will never achieve.
Add one line to what he's saying. The last 2-3 years, we now have a half-page note which is published by the Supreme Court on appointment of a particular judge of the Supreme Court.
By the Collegium.
By the Collegium, to show that there is some consideration. According to me, that is of no real use. But even assuming that is there, so it always says that we have taken into account the fact that this state is not represented on the court today.
Right.
Or that this minority is not represented on the court, or a scheduled caste is not represented on the court. According to me, these factors are not correct, in as much as if merit is the predominant feature, if one state is not represented, you can say that it is not represented today because we don't have somebody up to the mark. We look at it after 6 months again. Or if somebody from this minority community is not there today.
Who's good enough?
But we will defer that issue for another 6 months.
Right.
But to give these considerations, in fact, these considerations are overriding intrinsic merit.
Well, I have another point of view on that,
Yes.
which I'll express a little later, but I'll go back to the point that you made. And we've done some research on how judges are appointed in various courts in this country. And I've collected some data.
In high courts?
In high courts. I've collected some data here. And this data is as late as 15th of December 2024. It's updated. And I find here that on an average, if you look at all the high courts in the country, 40% of the judges come to the courts, higher courts, High Court and Supreme Court, who have been government advocates. Now that's a very dangerous trend. And in some states, I'll give you Chhattisgarh, it's 62%. Delhi High Court, 54%.
Gujarat
Guwahati,
is
54%. Gujarat High Court, 56%. You have 59% Telangana High Court. You have Manipur, 100%. You have Madhya Pradesh, 45%.
But
Now,
let me ask you a question before you go further. Do these appointments skew the justice delivery system? Is there a judicial process, judicial thinking, and ultimate judgments? Are they deflected from the law and from the facts?
Rationale which results in the kind of things that we are seeing today is that when I know that if I get onto a government panel, my likelihood of becoming a judge is much greater, then I'll curry favor with whichever government is in power, in whichever state, right? And I'll get close to that government, then become a panel judge, whether I'm good or whether I'm bad.
No, but are you then pro-government? Or if you are a public prosecutor, are you, against basically a pro-establishment in criminal jurisprudence?
We are seeing it today. I mean, I don't have to give examples.
What do you feel, Meenakshi? Do you see that trend?
We are seeing it. Not trend, it's a tsunami.
I think he's right. If you have been very long on a government panel or as a government counsel, you really tend to think one way. Apart from that, the problem is the entry into that. If the entry has been actuated by currying favor with the power regime, and you've got onto the panel and then use the panel as a stepping stone to a judgeship, I think we have very serious concerns.
No, that's
there.
the serious problem that's arisen today.
Because you do not want people who have used stepping stones with the power position and then come into judgeship, because it's very difficult to, the leopard doesn't change its spots.
But
How much ever be the time, a leopard won't change its spots.
We have had the most successful lawyer as being appointed Attorney General of India, and he was never affected by it.
He never came from that particular line as a government counsel. Never ever went in to ask
I'd like
for
to
any.
add something on this line.
Right.
See, you start by saying the lawyer is currying favor with the government.
That's one way.
To get on to the panel.
Yes, yes.
Currying favor, the phrase is used really if you are in a position.
No, not favor. I'm saying he wants to get onto the panel to
so let's
become
not
a
call
judge.
it, yeah.
That's not currying favor.
So no, I want to add another aspect to it.
Maybe the phrase is not right. You are
Phrase may not be
correct.
right. So all right.
Yeah.
So suppose I am a lawyer. I'm not doing too well, but I have a desire to do well. I don't get that opportunity to do cases. I'm willing to do cases at any cost or even free. So I want to get onto the panel to be able to show that yes, I can do cases for any government, because governments change, but government of India is the same. So I get onto a panel with a view that I will be able to show that I have the prowess to do cases. And if I'm okay, if I do well, I will come in the eyes of the court concerned, and I can become a judge. There's nothing wrong in that.
Completely
So
agree.
we should not probably say that every guy who gets onto the
No, we
panel
don't
is
say that.
only getting because of this, that, or the
We're
other.
not saying that at all. We are saying that.
I mean, we were also on panels in the earlier years.
No.
We did it only because to get exposure, because we had no other work.
Correct.
But Mukul, you have a classic example of Lal Narayan Sinha, who remained as an AG with successive 3 governments. Okay, so I don't think you can have a better illustration. So I agree with you that you will have outstanding people even there. But the problem is the current day selection seems to be leaning
I was only
more.
responding to the lawyer getting onto a panel.
No. The problem, I tell you, the problem is nowadays people don't get onto the panel that easily, even if they want to.
Yeah.
This is the problem. I mean, I don't want to say anything more.
Yeah.
I think we all understand.
I mean,
what I'm saying.
yes, the merit is not the criteria again.
No, there's no criteria.
Merit is not the
But
criteria.
देखो तो हाँ,
criteria.
exactly. I mean, so they
By and large.
There
By and
are
large.
other considerations also.
that's happened. I mean, we are seeing it. We are seeing the results of it today, right? So let's not say anything more than that. So this, and then ultimately in law, the source of recruitment matters the most. if you have 3-4 different sources of recruitment, they must be balanced. Right? So if you have a 50% source of recruitment of government judges, you will see the result in court. So this source of recruitment has to be limited, maybe 20-25%, and then you pick up judges from the pick up lawyers from the profession.
But let me ask you one thing. At least ask Mukul and Meenakshi. How far is the role of us lawyers responsible for this this mess that the judiciary is facing today, and how far we can contribute to cure it?
Quite frankly, I'm having this discussion only because of that.
But
because I know.
Only if somebody asks us. I mean, if nobody is willing to look at us or speak to us, what will a private lawyer do? If you have a discussion, yes. But if tomorrow the Chief Justice of India is to invite 5 lawyers, all of us can go and say, these are 5 things you should do because we are a part of the system.
No, but
attempt 2 or 3 things, maybe you
No, but I think as lawyers, we have failed in I personally think, as lawyers, we have also failed in our duty to publicly, right, express our concern at the level at which we are today, right, to inform the public that, look, you guys are leading lights in the profession. Your voice matters. And if you publicly state these things, it will have an impact. It will have an impact on the
I will completely endorse with what Kapil has to say. It was not so long ago that we at Supreme Court had very vehemently protested against bringing some judges to our court. And the lawyers were very vocal. They were huge.
The Supreme Court.
Yes. Justice Ramaswamy was not too
Yeah.
far away. And then I think we had another one judge thereafter against whom a lot of lawyers had given their concern to the Chief Justice. I think we have somewhere stopped speaking. But Supreme Court's not the only body that needs to speak up. I think it is our high courts that need to speak up because they are the ones who are getting...
Most of all, Bar Council of India,
Yes, Bar Council.
which
the
is
backbone is the High Court.
Yes.
The Supreme Court is
Yeah, I agree.
30.
No, but since you are leading lawyers of the country, your voice matters. This is why I'm saying. I mean, if you lead the way, there'll be others in the High Court who will speak up too.
I have a question, different question. Are lawyers responsible for the delays in the system?
Of course they are.
That's what is bothering me.
Of course they are. But then lawyers are not the only ones who are responsible.
Yeah.
Correct.
As you rightly said, if you don't have the infrastructure, if your High Court judges in Allahabad, right, just don't have the wherewithal, and if you have a clogged up case
What
diary,
should a man do?
what is the judge going to do?
See, it's all very
And what
well
is the
to
lawyer
say
going
that
to
bail
do?
is not being heard.
Right.
Fine is not being heard. The strength of the High Court is 100, but 50 people are, judges are working. Two judges are looking at bails, and their list is 1,000 matters. I've seen in Allahabad 1,000 matters on a day. What will the judge do?
It's humanly
And what will the
impossible.
lawyer do? What will the lawyer do?
Lawyer
He keeps on telling the judge, please hear my matter. He says, "ठीक है, let it come in its turn."
So, Dushyant, only by adding judges, according to me, even if you add
It doesn't make
10 times the number of judges we have today in this country, it won't matter. It won't help.
Because the quality of
It's a
justice.
self-defeating problem.
Unless it's a quality.
The nature of the laws,
That's right.
the nature of our hearings.
Correct.
Why hearings are extended? Because the judge who's sitting there doesn't have that experience.
That's true.
He's also, not very clear. He'll hear you, he'll hear me, he'll hear you again. Because he's not very clear. He doesn't have the experience. So it's a multifarious issues.
And the biggest litigant is governments.
Yes.
And the governments...
But I do remember, and maybe it's a trend to follow, but I'm myself a little unsure on that. You remember Justice M.K. Mukherjee, who sat on a criminal bench in Supreme Court. So when he came to Supreme Court, he had apparently told the Chief Justice that his expertise was only in that area. Throughout his tenure in the Supreme Court, he sat only on a criminal bench and complete even-handed dispensation with knowledge.
I will add
of
something
law.
more interesting. Justice Bhagwati, when he was Chief Justice of the Gujarat High Court, had a practice that whenever a new judge came, he would ask him, "Brother, what is the area of law you would like to really contribute?" And I remember when my father was appointed a judge, Justice Bhagwati asked him, and my father said, "I'm good with both civil and criminal law, so whatever you give me, I'll be more than happy. But I would like original side work, appellate side work. I'm not interested in bridge side of work."
Right.
And that's the system we don't have today.
Right.
I don't think we assign judges cases who have exposure or experience or knowledge of those laws.
Right.
And as a result of that, the hearings get extremely lengthy and long, they get adjourned time and again, and it doesn't really result into bringing quality judgments. So it is a big problem. I mean,
See, another way to look at it is, when you appoint judges, say in the High Court, if you say, I want one good commercial judge, one good criminal lawyer, one good company lawyer, one good IT lawyer, one good company lawyer, you start with that way, then pick out from those branches.
Correct.
But today, everybody is jack of all trades.
That's correct. That's
somebody, things like income tax, IT, all this is very, very complex.
Or even criminal law.
Right, even
It's
criminal
very, very
law.
complex.
Even criminal
Suddenly
law.
put somebody there,
Yes.
that man will flounder for a while. By that time, the roster
No,
is
if a
changed.
person has been doing IBC practice, he's the one who should be picked up as a judge.
Yeah.
But that doesn't happen.
Competition law.
Competition
And
law, he
allow
should be
them
picked up as
So
a
to
if you
preside on the
compartmentalize 6, 7, 8 main branches and pick out from those branches,
Yes, then-
you will broadly get some experts, no?
Yes.
Otherwise, you would say one guy will be jack of all trade. Today civil, tomorrow IT, tomorrow. He will have to learn on the job from different lawyers, etc. By that time, the roster is changed, he goes elsewhere.
No,
And
once-
at the expense of the litigant, because
Call it
obviously
expense,
it
call it
takes
what you
In England, Court of Appeal and Chancery Division have had judges who have dealt with a particular law for all their life as judges. But I have one more issue to ask. Has tribunalization of administration of justice,
been a
affected,
disaster.
Yet another issue.
has
Been a
affected,
disaster.
has affected the judicial system?
it's a-
the
My
justice
answer is
system?
emphatic, yes.
Yeah.
It should not have been there.
Correct.
They have farmed out the judicial process to a tribunal, by and large, where people with retirement benefits are being appointed, along with a government nominee. And really speaking, that has not lessened the burden. I mean, you cut out something from the High Court, it lands up in the Supreme Court.
And in
As
fact,
a first appeal, it's a mess.
and there is no disposal there.
There's no
either.
disposal there. That's the other
either.
thing.
There's another reason. Take the Electricity Act. Electricity Act is a very special act. Now, a particular judge is appointed to the electricity, this APTEL, as it is called, may never have done a single electricity case in one's life, say in a court like
Correct,
Jharkhand or Guwahati or wherever. Suddenly, you are in head of an expert body hearing appeals. How will
But
you
how does the
understand?
Supreme Court allow
But
that to happen?
also,
And then it goes to the Supreme Court, where the judge
No, but
himself may not have
why
dealt
does the
with an Electricity
why
Act
does the
case.
Collegium system allow that to happen? I'm asking you.
It's not the Collegium, it's the Chief Justice who's consulted or a senior judge
Whatever
who's
it
consulted.
is, whatever
Yeah.
is of that High Court or whatever the Supreme Court is consulted. Chairman of the tribunals are not appointed without consultation of the Supreme
Absolutely,
Court. So therefore, why are they appointed like this?
I don't know. And it is
No, you
increasing
know.
the burden on
You
High
know.
Courts and
You-
Supreme
you-
Court.
You don't know, you know. You know why they are appointed. That's the problem. That's the problem. Let me now go on to another issue. Way back in the 90s, I think in 1997, we had a restatement of values of judicial life, right? And there were certain principles evolved, and that restatement said, till a law is framed, judges must follow these values. What are those values? I'll just read one of them. Justice must not only be done, but it also must be seen to be done. The behavior and conduct of members of the higher judiciary must reaffirm the people's faith in the impartiality of the judiciary. Accordingly, any act of a judge of the Supreme Court or a High Court, whether in official or personal capacity, which erodes the credibility of this perception, has to be avoided. A judge shall not enter into public debate or express his views in public on political matters or on matters that are pending or are likely to arise for judicial determination. A judge is expected to let his judgments speak for themselves. He shall not give interview to the media. These are values 8 and 9. And 16 is every judge must at all times be conscious that he is under the public gaze. And there should be no act or omission by him which is unbecoming of a high office he occupies and the public esteem in which the office is held. Now, this is the restatement of values, and they have not followed that.
I would add one to that. They have forgotten that judges should not make irresponsible observations while hearing cases. That is really a matter of great concern today.
You know, the point is that if you lay down this restatement of values and you violate them on a daily basis, you're out in the media, all the time in the public space.
You remember there was one judge who acted as a judge on a platform in Allahabad.
Yes.
In Delhi.
Yes.
He was Allahabad High Court judge.
Allahabad High Court
Railway
judge.
station.
Railway
I
platform.
mean, he said, I will hold you in contempt if you are not giving me a seat. I mean, these are all aberrations which should be taken seriously.
But that reminds me of something I just read about. I think Justice Nagaratna had something for Justice Venkatramaya, and she said this. She said he used to say that there are not so many sacrifices that a judge makes, but he has to exercise a lot of self-restraint on very small personal things in life.
Right.
And that sums up broadly all that is stated here.
Right.
Now, when you scrutinize your people for selecting them as judges, you have to look at them actually much more closely. And I think that is why, Mukul, I would agree with you that when you start thinking about appointing people as judges, it's important that you start the process early. You bring the names out. You will receive all kind of comments. I agree. That's what they have held so far in disdain, that there are many things that come up against people. But you know how to separate the chaff from the grain, and you have watched those people. You just can't be having any kind of a recommendation which would come up and turn them into judges without realizing that there is basic character and a strength of character.
That depends on a broad-based cooperative movement from all sections. No?
Correct. Now, I will make a suggestion on this, but before I do that, I just quote what Justice Shekhar Kumar Yadav said. He said, I have no hesitation in stating that this is Hindustan, and this country will function according to the wishes of the majority living here. This is the law. It is not about speaking as a High Court judge, rather the law operates in accordance with the Bahu Sankhya. Consider this in the context of a family or society. Only what ensures the welfare and happiness of the majority will be accepted. Close quote. Why hasn't the Supreme Court taken action on it already?
Yes, I agree.
According to me, he should have been transferred straight away.
No, but I've been reading that the Chief Justice
Has set up an in-house inquiry.
has spoken to him
Yes,
and all
he
that.
has, he has.
But what has happened after that
We
has
don't
not
know.
come
I
out.
believe there's some.
They called him.
They
and
called him.
Collegium talked to
And
him,
he has
but
not-
he has defied.
He is defied.
But would you agree that is enough to send a message?
No.
Why transfer him? I think they should stop giving him judicial work.
Exactly.
I mean, where's the question
You
of
did
transfer?
that in Bombay High Court.
Yes,
Iqbal
yeah.
has just passed away.
Yes.
But he led that movement against those corrupt judges. I remember as a very young lawyer, there were 4 of them who were removed from Bombay High Court. One resigned, one was removed, and 2 of them, they stopped giving him work.
Absolutely.
Yes, that's correct.
So there was a movement, and I agree with you, it is a movement that has to start against judges like this, and unless and until we as a bar don't force it, believe me, it's not going to come from within the judiciary. I don't see it happening, because I think it's a very weak signal to only call the gentleman and we see no action. One would have expected an immediate action of stopping judicial work.
Right.
I would agree there.
Now, let me now make that suggestion of what I think should be done. We should have a permanent committee, right, set up by the Supreme Court, in which leading lawyers should be there, and government representatives should be there, sitting judges should be there, 1 or 2. That committee should be a permanent committee, right? They should find out from each High Court, by consulting leaders of the bar in that High Court, talking to the Chief Justice, as to who are the kind of people who should be elevated in that court.
And maybe 1 or 2 retired judges of that.
Yes, of course, of that
Who
court.
also have
right?
had that experience.
Right, have experience, who retired in that court. This process should start for a vacancy that happens 2 years from now or 1 year from now, right? So you will get a lot of names from all sides as to who are possible candidates. Then each candidate should be looked at by this committee, and some research should be done about his background, family background, other things, his values, right? His talking to his colleagues that what kind of a person he is in terms of integrity. Once you then you can shortlist people. Then you make the recommendation to the Collegium if you want to continue with this system. And then maybe you will come up with some better suggestions. This will include government lawyers also,
Yes.
who are doing exceptionally well. This is a system that can work. And this is my suggestion. What's your response to
I would agree with this. You must have a permanent machinery
Yes.
and broad-based, with full freedom
Yes.
for people to look at names,
That's right.
say yes, no, make out a dossier. of everything, speak to colleagues. I think it's a great idea.
I would just add one little thing to that.
Yes.
And I would say, have that scrutiny for a period of 1.5 or 2. And why I say that, it's very easy to go on your best behavior for 6 months.
No, he will not know. The person will not know.
There is no way, Kapil, they would not know.
No.
May not know.
May not know.
But have a period of time that gives you enough time. You can't be on your best behavior always.
But see,
so
Meenakshi,
have a
Kapil
reasonable
is saying,
length of time. then.
You are looking at 2 years ahead, na?
Yeah.
If you are looking at 2 years ahead,
There's
you
enough
know,
time in
enough
that
time.
square.
Enough time.
Yeah.
What do you say, Dushyant?
I would agree to that, but I want to say something more. We are concentrating ourselves on the High Court and the Supreme Court. But real problem is the lower judiciary. And lower judiciary can really, it is the backbone of justice delivery system, as we all know. If it is not efficient, if it is not competent, if it is not independent, then justice gets skewed. And I have 2 examples who really did remarkably well, and this is where Collegium is missing the point every time it appoints a Chief Justice in High Court. P.D. Desai was a judge of the Gujarat High Court who went to Himachal Pradesh, Calcutta and Mumbai. All 3 high courts and the judiciary of each of the 3 states, he really reformed remarkably. Now, as a Chief Justice, how many districts you have in a state? 20, 30, 40? Is it difficult for you to personally monitor the functioning of a district judge? And you have the power to transfer him. You have the power to appoint the best district judge in a particular district. Recently, if you go to Karnataka High Court, every lawyer swears by Justice Abhay Oak because he did remarkably well. He cleaned up, he was accessible, he did, during COVID, he would receive emails at 2 o'clock in the night and list matters next morning.
That's true.
So, what is really ailing today is that collegiums do not appoint Chief Justice in High Court after High Court who are competent, who are able, who are efficient, and who can really deliver results. They appoint anybody and everybody, and that is a big problem.
Add one more angle to
That's a big problem.
That's one. But see, the problem of appointments in the higher courts does not really exist in appointment of the subordinate
That's
judiciary.
correct.
For the simple reason
That's an exam.
that they have an exam in every state, like an exam getting into anything else. So by and large, that exam is not
on merit.
is not nepotism.
Yes.
I'm saying that is a far better system than
No,
what
we
is
are
being
not talking
followed.
about system. Once they are appointed, their functioning.
That's
their-
all right.
their-
But their appointment
But point
system,
is-
according to me, is far better than the system of the High
Dushyant,
Court.
that's a separate discussion that we are likely to have as to what's the state of the lower judiciary. Even though the merit system is there,
Yes.
in fact, the state is terrible. The lower judiciary, in the way in which they dispense justice, is horrible because the nature, the kind of things that are happening in the lower judiciary and the kind of influence.
I hear today that IO can enter into the chamber of a judge
So
and tell
therefore
him
that-
what order
that's-
is to be passed
that's
in a bail matter.
That's a separate discussion we're going to have. But at the moment, we're on what should be done to improve the process of appointment in the higher judiciary. I think we've touched
We are
on.
just now in the constitutional courts
That's
at the
right.
moment.
Yeah, exactly. And there's much more to be done, much more to
I
be
think
said
we
also.
should stick with
which
the
is
final
my suggestion.
that you have made, a broad-based, transparent
Permanent
system,
committee.
Permanent, like the permanent machinery of arbitration. So a permanent machinery
No,
for
no, correct.
appointment.
Should
There
not
should be
be
a
just-
secretariat. There should be a
And
secretariat.
manned by those who have no axe to grind.
Let me tell you another
Yes.
thing.
You, me,
No,
and-
it's something else. In fact, it should be manned by people who have no stake in the system.
That's what I'm saying.
Right?
Okay, that
If
also.
I am, for example, a successful lawyer and I'm there in the committee, every lawyer will want to come and brief
Yeah.
me. I don't want that to happen.
Yeah.
So therefore, that has to be done very carefully. But you can have a system like that.
But you will still have people who can rise
You'll
above
have to have some
themselves. I am
leading
very
lawyers.
sure about
Of
that.
course
Who
you
will
will.
not,
Yeah.
who will not.
In which the court have confidence.
Yes.
As Justice Verma rightly puts it in that judgment, under which they took away the power from the president to themselves, to the Chief Justice for appointing, he says all constitutional functionaries must be conscious that their responsibility in appointment is of utmost importance to survival of this democracy.
But he is the one, along with someone else, who said that I'm very disappointed as to how it's worked.
Yes.
Because I happened to be the lawyer along with Fali when we got the 1993 Advocates on Record Association case. We argued it. I feel bad that I was part of that. judgment, which resulted in this mess.
But you all did it in good faith,
Yeah,
keeping
because-
the independence of judiciary.
No, what happened was at that
your
time-
primary idea at that
Meenakshi,
time.
there was a lot of political interference at that point in time, which we were against. And we're up with
That has not stopped. Let me tell you
that has
that.
increased.
That is not,
But
yes.
then the pendulum went the extreme way.
Extreme
See,
way.
this is the problem.
Yeah.
This is the backlashes which happen. The pendulum
But
you
it's
see
not-
from emergency later.
Can I say one thing?
Yes.
You decided to do it to save the independence of judiciary from political interference. What has now turned into the judiciary getting politically inclined and the influences even more.
Yeah, it's very dangerous. But
I
anyway,
mean,
be that as it may,
unfortunately, your ideas didn't work.
we have
but
had
you
a
need to have
wonderfully
better ideas.
constructive discussion, and I don't think anybody should.
Let us end with one note, definitely, to which all of you will agree, that judiciary even today consists of some outstanding judges.
doubt
Undoubted.
No
No
doubt.
And we have
No
huge,
doubt.
immense respect for those judges.
Absolutely,
Yes.
yeah.
And they are doing their best to really deal with the situation. But yes, it does need to, revolutionize itself. And, it's not difficult for them to revolutionize and make it much far more better, far more efficient.
With that note, with that little comment, thank you very much
Thank
for
you,
being
sir.
here.
Thank you very much.